It is hump day, and I am feeling the Wednesday hump, okay? Welcome back to this channel. My name is Mandy Magnan. I'm an actress, writer, producer, and director in Toronto, a movie reviewer, a pop culture, and your YouTube commentator for everything It Ends With Never. We are getting right into it because Bryan Freeman has spoken to court and he is clapping back to Ryan Reynolds. Yes, we're going to get into it, as well as Blake Lively. We were supposed to be getting her opposition to the motion for summary judgment, but instead she filed an extension of time. We're going to talk about that. And yeah, let's just go. Grab your emotional support lip gloss. You are in frame with Mandy Magnan. Yesterday we went over the order compelling Jamie Heath to release all video footage of his home birth with his wife, NATASHA Heath. I've been kind of thinking about that, ingesting a lot of other people's content and opinions. First, I just want to say thank you to everyone who is using hashtag #IStandWithNatasha Heath. I feel still the exact same. I think it's absolutely disgusting that NATASHA Heath, a non-party in this lawsuit, has to turn over all of her very private, intimate, sacred birthing videos to Blake Lively. So gross. But the more I keep thinking about it, I first of all think that maybe NATASHA Heath could fight this and be like, no, it's my birthing video, my body, my choice, right? But then I also think that Blake Lively, I think, didn't think that Jamie Heath was going to fight this because of his beliefs in motherhood and the sanctity of motherhood. So I feel like she wasn't even fighting for the video footage. What she was fighting for was to silence Jamie Heath, because remember, she wasn't only asking for a motion to compel to receive all of the birthing video, but also she was asking for him to be sanctioned and pay all of her attorney bills, as well as be silenced and not be able to talk about this in front of the jury or during trial at all. And I think that's what she was going for. I don't think that she thought Jamie Heath was going to fight it because he doesn't want to produce all of his birthing video because of the way he feels about motherhood. And I think she was looking more to silence him than she was anything else. And it may have backfired or not. We'll see if they do comply with the court's order and hand over all of this footage. But the judge was very strict in his ruling to say that this is confidential, and nowhere, no way can any of this ever get out. So we'll see what comes from this and if Wayfarer are going to comply or not, and how that will turn out in the end. But Bryan Freeman has spoken in the court, and let's get into that straight away. After the motion for summary judgment, I am having a hard time talking today. Wow. Okay. After the motion for summary judgment was filed in the court, Blake Lively and Ryan Reynolds filed like a supplemental response to their May filing for sanctions. Why Ryan Reynolds entered the court again and wanted this beatdown, I have no idea. Nobody knew. It looked like a very staged PR move. And that was pretty much it, because again, they were referring to a filing that they had done in May. This is the response from Mr. Bryan Freeman. On behalf of Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie LLC, Melissa Nathan, the Agency Group PR LLC, and Jennifer Abel, collectively the Wayfarer parties, we write in response to the letter filed by Blake Lively on November 14th, 2025, seeking to leave to supplement the Rule 11 motions filed by Lively and Reynolds on May 2025. On May 19th and 20th, 2025, Lively and Reynolds filed Rule 11 motions arguing that the Wayfarer party's First Amendment complaint lacked factual allegations sufficient to support their claims and were therefore legally unreasonable and factually baseless. At the time the Rule 11 motions were filed, the court had not decided the motions to dismiss, which were based on the same pleading deficiencies cited as grounds for Rule 11 sanctions. In opposition, the Wayfarer parties argued that Rule 11 is not a proper vehicle to challenge pleading deficiencies that were already pending before the court in the motions to dismiss. The Rule 11 motions were fully briefed by June 10th, 2025, when Lively and Reynolds filed their reply briefs. Lively and Reynolds now seek to supplement their Rule 11 motions with excerpts from the depositions of Steve Sarowitz and Jennifer Abel, claiming their testimony demonstrates the Wayfarer party's counsel's knowledge that their clients could not articulate any basis to assert the challenged claims. The motion for leave to supplement should be denied for several reasons. First, as noted, the Rule 11 motions were fully briefed based on the notice provided. Before imposing any sanctions under Rule 11, a district court must adhere to the procedural rules which safeguard due process rights. Vacating an award of attorney fees under Rule 11 to the extent it was based on plaintiff's discovery misconduct, because Rule 11D excludes from the preview of Rule 11 sanctions discovery responses and motions that are subject to the provisions of Rule 26 through 37 of the Federal Rules of Civil Procedure. Chief among these rules is Rule 11C2, which requires the party seeking sanctions to describe the specific conduct that allegedly violated Rule 11B in its moving papers and give the offending party 21 days before filing the motion to withdraw the challenged paper, claim, defense, contention, or denial. These provisions are intended to provide a type of safe harbor permitting a party or attorney to avoid Rule 11 sanctions by withdrawing the questionable contention within the 21 days period. Second, the Abel and Sarowitz depositions were not recently discovered evidence, as their depositions were taken on September 26th and October 3rd, respectively. Lively offers no explanation for filing for letter at this juncture. Just days after the Wayfarer party's summary judgment motion? Okay. Lively's reliance on Sarowitz and Abel's answer to deposition questions about the basis for their legal claims, coupled with the letter's odd timing, reflects an apparent effort to reassert control over the news media cycle. Dang, finally say it. All they've been doing is using this court for PR since the beginning. I love that. What does it say? Lively's reliance on Sarowitz and Abel's answer to deposition questions about the basis for this legal claims, coupled with the letter's odd timing, reflects an apparent effort to reassert control over the news media cycle. Third, whether a client can articulate the basis for his or her legal claims at deposition is not the relevant inquiry. Lively and Reynolds mistakenly attempt to draw some importance to the fact that Sarowitz and Abel were unable to answer questions at their deposition concerning the allegations in the complaint, without relying on cite from their lawyer. But a party is not expected to answer questions at his or her deposition about the factual basis for his or her legal claims, particularly when, as here, the allegations are based upon counsel's investigation and later discovery rather than the party's personal knowledge. As noted by Lively regarding her own inability to articulate the basis of her claims at deposition, it makes no sense to suggest that facts in a party's personal knowledge, as opposed to facts developed from the public record from an investigation of others and through discovery, would be particularly relevant to, never mind dispositive of, the nature of the challenged conduct. And that's from Lively herself on her motions to strike, and then the Judge Lyman himself granting it. Okay, so Lively, if it was good for you, you couldn't even answer your own questions in your deposition, and you're trying to do this to Abel and Sarowitz. Get out of here. Fourth, the Sarowitz and Abel testimony ignores other evidence uncovered in discovery, which demonstrates that, in fact, there was ample evidence to support the defamation claim against Reynolds. Yes, you heard that correctly. They found all the evidence they needed. Ryan Reynolds, what are you doing to yourself? What are you doing, bruh? A document produced by Lively reflects Reynolds blank, and that's from Brian Freeman's declaration. Reynolds also produced documents in this action pursuant to subpoena. Those documents show, among other things, that Reynolds, and then Reynolds also told somebody, oh my gosh, and then it's just redacted. G. Reynolds also remarked too, and then it's redacted. The evidence also demonstrates that Reynolds overtly attempted to interfere with Baldoni and Wayfarer's relationship with WME. Reynolds blank on the Wayfarer parties. Emmanuel has since acknowledged responsibility for firing Baldoni from WME. In short, the Wayfarer party's claims against Reynolds were not factually without foundation, but were in truth supported Reynolds' own written words. For the foregoing reasons, the Wayfarer parties respectfully request that the court strike Lively's letter and accompanying declaration and deny the related motion to seal as moot. If the court does grant leave to Lively and Reynolds, the Wayfarer parties respectfully request that the court grant them leave to file a fulsome, substantive response to the letter within 2 weeks. Woohoo! So basically, if Ryan Reynolds keeps fighting this thing and is actually wins this motion, the Wayfarer people, I think, are going to start dropping real things against Ryan Reynolds that we're all going to be able to see, and proof that, you know, he did do the things that Wayfarer claimed and he was defaming Justin Baldoni. Let's go. I mean, I would love to see everything they have against that man. For sure, 100%. It seems now like Blake Lively is trying to ask for an extension to reply to the motion of summary judgment, but the judge did put a ruling in that he wanted to rule on the motion for summary judgment at the exact same time as motion for judgment on the pleadings. So they had filed that one first. Then they, had the meeting with the judge, and Judge Jolling was like, well, it's fine. Put everything together. I'll extend the deadlines and I will rule on both of these together. Well, it seems like Blake Lively now is asking for an extension on her reply. Let's see what she has to say. Plaintiff Blake Lively writes to respectfully request a 2.5-week extension of the current deadline for all parties and third parties to move for the continued sealing of documents filed under seal in connection with the Wayfarer defendants' November 12, 2025 motion for summary judgment against Ms. Lively, extending from the current November 20th deadline through December 8th. But remember, their meeting for the judge is on December 6th. So this would actually extend their reply past when they're supposed to meet the judge, which has been on the deadline of the docket for months now. And she wants a deadline through December 8th. Ms. Lively makes this motion only after extensive efforts to meet and confer with the Wayfarer defendants to develop a workable and fair plan for handling sealing motion in connection with summary judgment without success. As part of their motions, the Wayfarer defendants filed more than 275 exhibits. Of those, 183 exhibits were filed under seal, but were not served upon Ms. Lively until after the November 12th summary judgment filing deadline. But everything they filed, Blake Lively has had in her possession throughout all of fact discovery, so nothing new should have been presented to them, because a lot of the things they got were in depositions that her lawyers were sitting in, as well as all of the footage they've already provided to Blake Lively, as well as all of the testimony and stuff from Blake Lively's own communications. So they've had all of the information that was filed. Okay, anyway, we move on. In addition to the more than 100 sealed exhibits that are documents produced by or otherwise involving Ms. Lively, the Wayfarer defendants filed under seal confidential documents and deposition testimony involving 15 third parties. Despite implicating the rights of these 15 third parties, the Wayfarer defendants apparently did not notify these parties until yesterday that documents and or testimony that they provided were filed under seal as part of the motion. This plainly violates Rule 4B of Attachment A to your Honor's individual rules. Oh my gosh, don't think now. They're just trying to make the Wayfarer out to be these big bullies, like they're bullying all these people. If you sat down for deposition, your deposition is going to be used by either Lively and or by the Wayfarer people, or both, and you're probably going to have to testify in court. I mean, it's not a big secret that if you got pulled in and subpoenaed and sat down in a deposition, your testimony at the deposition will be used for either party. I mean, that's the point, isn't it? Further, she says, on at least 2 occasions, Ms. Lively has learned that the Wayfarer defendants have represented to third parties that the Wayfarer defendants and Ms. Lively have reached an agreement to extend the current deadline for continued sealing to November 26th, which is not accurate. So it's not true, but it's not accurate. Prior to making the present letter motion, Ms. Lively requested, as a professional courtesy, the Wayfarer Oh gosh, just always boosting herself up so greatly. Like, we did everything, Your Honor. We did it so right. We were trying to be such good people. We're here because y'all are some ethical, shady ass people who are trying to extort this man and destroy his lives, and along with all of his family too. The Wayfarer defendants' agreement to a 3-week extension of the current sealing deadline, which would afford Ms. Lively, as well as the other third parties, sufficient time to review the more than 180 documents filed under seal. Why do the third parties have to review all of the documents under seal? They shouldn't even be able to see it. They sat for deposition. That deposition is to prove a case. And Blake Lively already had all of these filings. She got them with her lawyers through fact discovery. While also accounting for the 12 noticed expert depositions before December 12th, Ms. Lively's opposition to the motion due December 3rd, opposition to the motion for judgment on the pleadings also due December 3rd, and reply in support of Ms. Lively's motion for spoliation sanctions due December 5th. Ms. Lively has granted similar courtesies to the Wayfarer defendants in relation to her motion for spoliation sanctions without requesting anything in return. It's already been extended because of the Lively parties. Like, that's why we're here. That's why everything has already been pushed and extended because of Lively and Jones. They got together and asked the judge to extend it. They've already been extended. Then they go into how they agreed to a 22-day extension of the deadline to file the opposition to Ms. Lively's motion for spoliation sanctions, agreeing to a 7-day extension of deadline to seek the continued sealing of exhibits filed under seal in relation to Ms. Lively's motion for spoliation sanctions. However, the Wayfarer defendants rejected Ms. Lively's request and offered 1 week to November 26th, which is 1 day before Thanksgiving. Oh no, not like you ruined their Christmas when you filed your CRD complaint and the New York Times story right before Christmas. Oh my gosh, boo-hoo. They're offering you 1 week. 1 week extension. Why do you need 3? You have the best of the best of the best lawyers in the country. Ms. Lively now regrettably makes this letter motion seeking to extend the current November 20th deadline for all parties and third parties to seek the continued sealing to December 8th. No previous request for adjournment or extensions of time had been made with respect to this deadline. Yeah, of course it hasn't, because there is only one deadline for this. When would you have... Oh my gosh. Anyway. Counsel for the Jones Party, JonesWorks LLC, and Stephanie motherfucking Jones consent to this request. Oh my gosh, shocking. The Wayfarer defendants oppose. The date of the party's next scheduled appearance before the court is now December 9th. Alternately, in an effort to promote judicial economy and avoid piecemeal motion practice, Ms. Lively requests that the court extend and modify the timeline set forth in Rule 4B of Attachment A to Your Honor's individual rules and practices in connection with this motion. Specifically, Ms. Lively requests that the producing parties who may wish to move for continued sealing or redaction of any material submitted in connection with the motion be permitted to file a single omnibus submission addressing all such requests within 1 week of the motion being fully briefed or by December 19th, 2025. If adopted, that procedure would permit the court to review all of the sealing and redaction issues in connection with the motion at once, aided by a single letter from each producing party and without receiving a fresh wave of such letters each time the motion, opposition, and reply papers are submitted. It would also serve the interests of public access in connection with the papers supporting and opposing summary judgment for there to be a single moment of unsealing that is not specifically connected to which party submitted the evidence when the court is able to resolve all the sealing issues simultaneously in a single decision. Wow, Blake, thank you so much for caring about the public and how easy it will be for us when you just unseal everything all together instead of just one by one or however you choose to do it. I mean, the fact that you're thinking of us internet sleuths now and really trying to serve the public, wow. But you're also in this letter really trying to make it easy for the judge, make it easy for third parties, and of course, make it easier for yourself. Ms. Lively suggested this alternate proposal to the Wayfarer defendants, who did not agree and who opposed this request. Counsel for the Jones parties consent to this alternate request. Counsel for the Jones parties consent to this alternative request. It is respectfully submitted that this proposal will aid judicial and party efficiencies in confronting the volume of proposed redacted material that will be submitted in support of and in opposition to this motion. It does say in the footnote, as part of her motion for spoliation sanctions, Ms. Lively filed 51 exhibits under seal, less than a third of the total exhibits filed by the Wayfarer defendants in their motion. What does that have to do with anything? There are different motions. You filed a motion for spoliation. They're literally filing a motion for summary of judgment and a motion on the pleadings. Different things. So, and then when they said that they made an error in the deadline, that in the footnote she wrote, the Wayfarer defendants claim these misstatements were made in error. Okay, see Exhibit A. We shall. So we got a little email chain here. So like usual, we'll just go all the way down to the bottom and work our way up. And now this better say exactly what you're saying it says, Blake, because I know how you like to spin the truth a little bit here. We have an email that went out on November 17th at 4:46, and it starts with Blake Lively's lawyers, and this is from Matt Bruno. It says, Kim, the Wayfarer defendants filed more than 180 exhibits under seal, and it is our understanding that third parties who designated information confidential have not been given notice of the sealed filings. We also know that we did not receive the sealed exhibits until well past the deadline, into the early morning hours of November 13th. Given the volume and logistical issues, we need additional time for all parties to review the documents before we can take a position on moving for continued sealing, especially in light of the Thanksgiving holiday coming up and our pressing focus on the summary judgment, motion for judgment on the pleadings, and expert depositions. As you know, we have been generous with extensions, including granting a substantial extension on the Wayfarer defendant's opposition for the motion for spoliation sanctions. Accordingly, we request a 3-week extension of time for all parties to move for the continued sealing of documents filed in relation to the Wayfarer defendant's motion for summary judgment. We would appreciate the professional courtesy given the circumstances, the Thanksgiving holiday, as well as the fact that Ms. Lively previously agreed to several extensions for the Wayfarer defendants. Please let us know today. If it was me and you've been ruining my entire life and ruined my Christmas and is literally trying to destroy me and bury me, as well as intruding on my wife's privacy and all of the things that they've done, I would just say no. No, I will be giving you nothing. I would play the hardest of hardballs. I'm not even lying. Then we do have a reply here. We are amenable to the requested extension and would suggest a parallel extension in connection with Ms. Abel's motion for conditional summary judgment against Jones Works to keep the issues on the same track. Please let us know if you agree. That sounds nice enough. They're, playing ball. Then we get a reply from Lively saying, thank you, Morgan. This is fine from our perspective. Could the Wayfarer defendants please advise? We would like to get a stipulation on the docket today. And then we have an answer from a lawyer from Wayfarer, from Shapiro, who says, Counsel, we understand the importance of courtesy extensions and remain hopeful that the parties will continue to cooperate with respect to adjusting deadlines to the extent possible and as appropriate. At the same time, we are mindful of both the Second Circuit's and Judge Lyman's admonitions that sealing issues be dealt with promptly, given the public's right of access. Accordingly, we are amenable to a 3-day extension of the deadline so that third parties can be contacted and any necessary meet and confers can proceed. We will contact the third parties separately, given that Ms. Lively does not have standing to speak for their concerns. We also note that the agreed upon schedule for summary judgment and Dubart briefing was based on our understanding following discussions with you. We will contact the third parties separately, given that Ms. Lively does not have standing to speak for their concerns. We also note that the agreed upon schedule for summary judgment and Dubart briefing was made based on our understanding following discussions with you that Ms. Lively would be filing a summary judgment motion on her own, In multiple discussions, you never advised us that she would not be doing so. Thus, when we agreed to the schedule, we did so with the understanding that the sealing deadlines under Judge Lyman's rules would apply to both sides, and that we too would face the time constraints of those rules in working out any sealing issues. Moreover, in discussing that schedule, you propose extending the sealing schedule by a similar extended period of time. And we did not agree because of the public interest in disclosure. So we don't see any reason to renegotiate that issue now. Separately, we note that we do not object to redacting personal information on any document that is unsealed. And we are happy to advise the court that we will refile any such document with appropriate redactions after the appropriate scope of sealing is determined. Well, my, oh my, she didn't put that in her letter now, did she, Blake Lively? Okay, there's a lot more of an argument here than the one that you just gave to the judge, or at least tried to tell the judge about. That from the beginning you've been trying to negotiate this extension of time. Interesting. And then Bruno from Manat, Phelps, and Phillips, Blake Lively's lawyers, answer back. Alice, the Wayfarer defendant's refusal to extend the professional courtesy of a modest extension to afford Miss Lively, the Jones party, and the other third parties sufficient time to review and evaluate the more than 180 exhibits filed under seal is disappointing, especially when similar courtesies have been extended by Miss Lively numerous times at the Wayfarer defendant's request. That said, in an effort to find compromise, please advise whether the Wayfarer defendants will agree to a 2-week extension, which will push the deadline out from the Thanksgiving holiday. Please confirm by COB today whether the Wayfarer defendants agree to our requested extension. If not, we will move for such relief and inform the court of your refusal to provide the basic courtesy. I am hopeful this will not be necessary. What? They're straight up bullies. And then we get from Shapiro, thanks, Matt. Our team is dispersed at the moment. We will consider and get back to you as early as tomorrow morning. And then he follows up with her saying, Alice, this is a time-sensitive issue that will require the court's immediate attention if the Wayfarer defendants do not agree to our request for a 2-week extension. As such, we need the Wayfarer defendants' position today. It has also been brought to our attention that members of your team are representing to third parties that we have reached an agreement to extend the sealing deadline to November 26th. It is our understanding that the extension you offered below was to November 24th, not November 26th. But either way, it is obviously not accurate to characterize this as an agreement when the parties are still discussing the deadline. It puts undue pressure on third parties, particularly when we are seeking more time to consider these issues, which would benefit third parties also, and the Wayfarer defendants failed to give third parties notice until now. Apparently, Matt. Then Kim writes back quick. Matt, this was my error to the third parties and I will be correcting it. Please do not speak to the third parties as you do not represent them. Dang. And then that's it. I'm assuming the judge will have to rule on this straight away since Blake Lively's opposition is due. So I'm sure the judge is really going to rush for this order, but the way she worded it, and then when you read the emails, you're like, wait a second, you've been trying to get this extension since before when you were trying to trick everyone. Let's negotiate how many pages it can be because we're going to be filing our own, and then they never even filed. So they got them to negotiate all of these things within the summary for motion judgment based on them also filing one that they didn't even file. And since then, they've been trying to get this 3-week extension. Why do y'all need 3 weeks? The documents that were filed in summary judgment, first, your lawyers were at those depositions. And it's a lot of communications that Blake Lively herself filed. You already have all the documents. It shouldn't be that hard. And you should have been preparing for this. But I digress. Anyway, that's everything that's been happening so far. That's everything for today. If anything else gets filed, of course, I will be here for you. I hope you're having a great day. And yeah, I don't know. I'll be back soon. I'll talk to you later. Love yourself a little bit more today. Take care of yourself. It's kind of a very kind of week. I'm feeling it for sure. Just a little bit more, less sunshine, a little bit heavier. So give yourself a big hug for making it this far. Love yourself a little bit more. I love you, and I'll be talking to you soon. Bye. See you.